On June 6th, the U.S. Supreme Court sided with Native American tribes on how healthcare programs are funded. It was a 5-4 opinion, and it upheld 2 rulings by federal appeals courts. It ruled that when a tribe takes over running their own healthcare programs, the government will indeed need to step in to cover some of the overhead and administrative costs. Chief Justice John Roberts wrote the majority opinion, and he said stepping in to pay those costs is necessary to prevent a funding gap. It's actually a federal law that allows tribes to take over the running of their own healthcare programs. It's the Indian Self-Determination and Education Assistance Act. It actually gives tribes the option to enter into a contract with the Indian Health Services to run their own healthcare programs. Indian Health Services then would give tribes the money it would have spent providing those services and running those programs. And the tribes can collect from Medicaid, private insurance, or Medicare. The design is intended to give the tribes more local control. It makes sense that in the Supreme Court majority opinion, they said if you didn't allow the costs to be given to the tribes, it would force the tribes to essentially pay a penalty for pursuing self-determination. U.S. Department of Health and Human Services was on the other side of the coin in this fight. They said they should not be responsible for paying some of these overhead costs to the tribes. First of all, because of the price tag. They said that's $800 million to $2 billion a year. And they said the tribes do get some overhead money from the feds, just not the amount that they want, not the extent that would come under this ruling. HHS said they don't want to be responsible for the overhead associated with third-party income, and ultimately, the U.S. Supreme Court disagreed. You can read that opinion in its entirety. We link to it in the description below.